Thank you. Gosh, I'm so gratified. I was worried that this would be an extremely small and intimate crowd because I'm fascinated by people's fascination with this topic. Just before I get into the sort of meat of it, I have to say how wonderful it is to be back at the college that time forgot. I mean, 25 years. I was here 22, 21, 20, I guess, years ago. And nothing has changed. The bar is gone from this room, Mark reminds me. But wandering elsewhere, it's as if every blade of grass seems to be in the same place. And in fact, Mark was making cheeky reference earlier to the fact that my main claim to fame in the early part of my career was having been wrestled to the ground by a bunch of RCMP officers on the lawn just up there during the APEC conference in 1997. And I was holding a sign that was fashioned out of a coat rack that said democracy or some equally contentious prospect. And I sort of became the meat in an RCMP sandwich. But the coat rack that hung the sign is that one that's right there. And if you look closely, you will still see the tape residue. You'll be wondering, whoever was such an idiot to tape something to this coat rack? Well, that was me, and that was the coat rack. And the other one, we had two coat racks that day, is just in the doors of Graham House here. So it speaks to either a very spare budget or a strong sense of history. But wandering around this place, I really do feel like I'm home again. And as the bio, I think, mentioned, my wife Amanda and I were the first people to be married, actually, at Green College, at Graham House in 1990, better get this right, 1999, a year after I graduated from the law school. So just all a way of saying I'm so grateful to Mark to have me back. It's been thrilling, even if the rest of the evening goes to hell. It's been wonderful so far. So as Mark mentioned, I graduated, left Green College, and started a career as a litigator with a kind of academic bent as well. I went off and took breaks and went off and did some graduate work and that sort of thing. I became a litigation partner at a firm downtown, Bullhauser and Tupper, as it then was, and then promptly left that to join the Ministry of Attorney General in their constitutional law group, doing some of their constitutional cases. And then 6 years ago now, parachuted from there into academia. My wife Amanda teases me that every 6 or 7 years, like clockwork, I managed to find a less lucrative career than the one that preceded it. So she's right, of course, but there's still it's a very nice way to make a living as a lawyer. You think, you read, you write, you talk, and someone pays you for it. It's the most unnatural economy you could imagine. For those of you who are in law school, who do we have here that are law students? Oh, wonderful. Well, thanks for coming out. I mean, it's, you guys have a skill set that at any other time and place in history would have got you stoned to death by your fellow villagers, right? Get that annoying guy Jones out of here. But it can be, handsomely rewarded in today's society, and I think if you do a good job, you deserve it. My background in litigation, when I went to my academic position at Thompson Rivers, led me to, it gave me the opportunity to sort of exercise my curiosity about what it was that I've been doing for the last 20 years. I suppose close to 15 at that time, but this idea that, we are, as litigators, professional persuaders, and the understanding that we have of how we come to know things, how we come to be persuaded of things in particular, has really been revolutionizing in the last 10 or 20 years. You only have to look at election cycles or social media or anything like that to really understand that the things that we are taught, particularly in law school, that law is just a mathematical application of established rules to knowable facts without really anything in between. That's so incomplete a description of what it is that courts are doing, and a really incomplete description, therefore, of what a lawyer's job is. So I have way more slides probably than our time together today can accommodate. So I'm going to move through them with some speed. I want to introduce you to a new model of human decision making and describe its role in legal advocacy. And to some of you, this won't be a new model at all if you have any background in psychology or social psychology or even neuroscience. A lot of this is probably going to seem kind of sophomoric. But I hope what is new to you is thinking about ways in which it's sort of working its way through the legal system and how it may well revolutionize the legal system as we go forward. And then I want to give you some examples of what are called heuristics and biases, these subconscious techniques that we use for fast and frugal decision making that so often, or increasingly often, I think, run amok with our decisions, and how that's actually visible to an extent in the judicial decision making process. And of course that leads to the question of how these heuristics and biases, how these subconscious processes can be manipulated by advocates. In fact, how they have been manipulated by advocates for thousands of years, but now it's becoming a sort of scientific process in a way that it wasn't before as our understanding increases. So this is my kind of personal hero, I guess, as I've gone through my legal education. This is Oliver Wendell Holmes Jr., and he was one of the prominent legal realists in the early part of the 20th century, and he was a very well-regarded judge among some of his other achievements, and also a dedicated academic. He really wanted to be involved with teaching, and so he did teach a fair amount and lectured at Harvard Law School in particular. But he and his fellow legal realists said, you know what, this algorithmic stuff, this rules and facts, fetishism, isn't really explaining everything that's going on in judicial decisions. So he just set out this very simple proposition. The prophecies of what the courts will do, in fact, nothing more pretentious are what I mean by the law. If we don't understand how judges are coming to decisions, then we can't predict what's going to happen in a particular case, and moreover, we're hobbled from influencing what happens in a particular case. So this was very, I guess it rang a lot of bells for me, because I look back on a fairly successful career as a litigator, and I thought, I've won a lot of cases, and I don't know why. And I lost a lot of cases. The old litigator saw that I never lost a case that wasn't wrongly decided, right? You're convinced that you're going to win it, and you lose it, and you don't know why. And so you pour through the judge's reasons and try to figure out why. But what if the judge, him or herself, doesn't really know why they made the decision? And that's the sort of uneasy conclusion that I reached fairly on in this research, and that's been borne out for me again and again and again, that one of the least reliable indicators of why a judicial outcome occurred a particular way is the statements or the explanations provided by the court of why they came to a particular decision. So Holmes's challenge is for us to say what's going on. If we want to be in the prediction business, if we want to be in the influence business, we have to have a more nuanced understanding than the sort of formalistic model, which is almost all we learn in law school. The rest of the stuff we're just supposed to, learn by osmosis after we get out. Okay, so I like to frame the work I do in advocacy as the Greeks did with their rhetoric. That is to say, to divide it roughly into three categories of persuasion: ethos, pathos, and logos. And logos is really what we teach in law school. That's where you're saying we should come to a particular conclusion because logic demands it. Here's the rule, here's the application. And I say that this is incomplete because it relies on the assumptions that the rules established and objective facts discovered will actually determine future cases, and I think that's a bit misleading. and also that the judicial reasons actually reflect the real reasons for the decisions made, and I'll show you why I don't believe that they necessarily do. Okay, so just a bit of background, and this is, new stuff learned to me. I don't have a psychology background. I certainly don't have a neuroscience background. I have a fascination with it, I think as many of you probably do. I read a lot of those pop books. I did the case for the government, the polygamy reference, and that was very heavily, our evidence was very heavily founded on evolutionary psychology and human mating behavior in that case. But I got to read a lot of work by evolutionary psychologists, and some of that started to touch on persuasion and advocacy and how we actually come to beliefs, how we communicate ideas. And so that sort of got me down this path. But what we're learning now is that most human decisions, by most estimates around 95%, but some psychologists are now claiming that it's 100% of our decisions are made subconsciously and extremely quickly. And that our conscious brain believes it's making the decisions, but actually becomes aware of them only after they're made. And some people call this, the conscious brain, the excuse maker in chief. That it essentially is a way of us arranging our decisions and to explain them to ourselves with the idea, some psychologists believe, that consciousness itself evolved as an adjunct to communication, to language, and it was our evolution as a social animal, our need to organize, to cooperate through persuasion in many cases, that necessitated a way of us being able to put something in communicable form and then being able to communicate it to others, to urge them to action. But what's kind of lost in that evolutionary imperative is the truth. Because truth does not necessarily extend the genetic interest or the evolutionary interest of the individual. It might, but if it comes clashing with other imperatives, for instance, the formation of alliances in a small community, then truth can be expected to be sort of the secondary factor, if even that. And so those are sort of things in the background that help explain to me why what we're finding is going on, or why it is going on. So the conscious brain creates this framework, but the decisions are made subconsciously and quite often sub-rationally. I mean, the subconscious brain can still be perfectly rational, right? But it can also be sub-rational through the use of these fast and frugal decision-making shortcuts that we call heuristics. And that's been sort of the focus of my research and writing. Let me just see if there's anything I haven't touched on here. No, I think I can fly through that. So it's helpful to sort of imagine the way these behaviors, these thinking behaviors evolved, because we were in a very different type of society in the Paleolithic age when our evolution, it didn't stop, but it certainly, we are cognitively 200,000 years old. We are not made to live in million-person cities, and most importantly, we're not evolved to interact with strangers to any great degree. And that affects all kinds of ways that we make decisions. How we judge somebody's confidence, for instance, very different when it's a stranger from when it's an intimate, and that affects the way witnesses, for instance, are presented in the courtroom. But I don't want to digress too much at this point. So, in this environment, between 50 and 150 people, Dunbar's number, that's sort of the ideal human community, they reckon. Alliances, obviously crucial for survival. Assessment of truth has value in many instances, but is not an independent value in itself. Deception and manipulation of compliance are crucial skills. So this, and so is the detection of deception and manipulation. So we kind of got in an arms race about being able to deceive our fellows and also being able to detect deception in others. Self-persuasion or self-deception has been argued by some evolutionary psychologists as a basis, as a method of better deceiving others. There's no better way of persuading somebody of something unless you believe yourself. And that's what we lawyers are always taught. You have to believe in your case. Well, why? Because you're more convincing when you believe in your case. And boy, it's not hard to convince people to believe in their case. I do a fun thing with my advocacy students who are second and third year students. I say, think back to your first year MOOC, where they're all just assigned a side, and they're all doing the same facts. And I said, okay, so half of you were appellants and half of you were respondents. Who among you here thinks that just on the facts and the law, you should have won your MOOC? Whether you did or not, on the facts and the law, should you have won? Everyone puts up their hand. I mean, it's like without fail. And I say, look, half of you must be wrong, right? But you've been assigned a role, and that's a very powerful influencer on what you in fact believe to be facts. Anyway, another bit of a digression. Okay, so System 1 and System 2. System 1 is sort of referred to as the reptile brain, and System 2 is the conscious mind, the I that you think of when you say I something. That's the conscious brain. But the role of the subconscious, well, let me just talk about this split brain thing for a second. There's these people that have their corpus callosum surgically severed because they suffer from grand mal seizures, a very severe form of epilepsy. And so the sort of last-ditch treatment is to cut the neural bridge between the two hemispheres of the brain. And these people don't suffer much in their everyday life because the information received by both hemispheres in most circumstances is the same. One ear goes to one side of the brain, one eye goes to the other side of the brain. And so they don't really notice it. What they do notice is a great deal of income from psychology experiments, because the fact that they do have independently operating hemispheres allows psychologists to play some very interesting games on. So for instance, they figured out a way to just beam a message to one side of the brain or the other. One side of the brain in almost everyone is very dominated by System 1 and the other side by System 2. So they flash to the lizard brain a message like, get up and leave the room. And the person dutifully gets up and leaves the room. And then they come back in and they say to the whole person, so why did you get up and leave the room? And the person will say, oh, I had to get a Coke. I was very thirsty. And that's the absolute truth for them. Right? That's not a lie. That is their conscious brain constructing a reality that explains what would otherwise be inexplicable because they don't know why they got up and left the room. And they do very similar experiments, and they've done it. I mean, it's extremely well demonstrated that this happens. And that explains, some of why eyewitness testimony, for instance, is probably the least reliable kind of testimony that you can come across in the courtroom. Biases are hidden even from ourselves. When I talk about biases, I don't really mean prejudices. That is sort of socially constructed particular biases against a racial minority or against women or something like that. But they're not unrelated. Most of the ones that I study are kind of hardwired things, and I'll sort of explain them to you. But the way that we justify our decisions is important. The experiment that Laudenau describes, it was just, they would send out resumes for a fictitious position, and they would ask people to assess the resume and basically choose who they wanted to hire. And the position that they chose was one, I think it was a executive at a software firm, but it was traditionally one that had been held by men. And the resumes were randomly assigned to male and female names with either a strong street smarts component or a strong academic component. What happened at the end of the day was both men and women hired hired overwhelmingly the men, and yet each of them, when asked why, would say, well, this job calls for street smarts, if it was the man that had the street smarts resume. But they would say, oh, no, this job clearly needs strong academic qualifications, if it was the man that had the academic qualifications. So when you think about the judicial decisions that I'm going to start discussing, understand that if you have a zone of discretion of explanation, you may not be getting anywhere close to the actual reason why the decision was made. Because each of these people would, in very good faith and in absolute truth as far as they're concerned, say, I made this decision because of my objective assessment of the resumes and what I thought would be appropriate for the job. And judges will be doing the same thing, as we'll see. Okay. So how do you tease this out, right? How do you actually study it? Well, you can try to do controlled experiments, and I'll talk about a few of those, but they're very difficult, particularly because it's very hard to get judges to cooperate in them. I can tell you a story about sitting with the Chief Justice and saying, I'd love to come up to Whistler for your meeting and run a few, questionnaires on your judges to try to prove that they're irrational. And you can just imagine the paternalistic smile that I got in response. So it's very hard to actually run experiments, but some have, and I'll talk about a few of those. But one way you can do it is you can try to tease it from statistics. You can see what actually works in courtrooms, and you can look for patterns, because these things should have patterns if they skew a predictable way. One of the difficulties about doing that in the legal setting is it's very hard to even get apples and apples, right? Get a data set. Like you can say, I want to study whether female lawyers or male lawyers succeed more often in the courtroom. Well, how are you measuring success in the courtroom, right? You might say, judgment for the plaintiff, $600,000. You might say, what a great win for the plaintiff. Well, not if it's a $2 million case, right? So how do you actually assess even who won or lost in a particular case is a huge challenge. Okay. So if judges' decisions are based on extrajudicial or non-legal factors that are hidden from normal analysis, then it's impossible to determine the true reasons for a decision by asking the judge. It will be impossible to determine whether a bias influenced the decision in a particular case, and therefore the appellate process, as we'll see, is not necessarily a panacea for correcting these things. And of course, the risk that we run, particularly as our knowledge of these things becomes very focused, is that it will be more and more used to manipulate the judicial process in a way that undermines the rule of law. Okay, I think we've dealt with what is a heuristic. Let me give you two quick examples. Decision fatigue. This is the one that actually sort of pulled my eyebrows over my head initially, and I had to really rethink everything. So what decision fatigue is, look, thinking is costly. Conscious thinking is costly. It's costly in terms of energy expenditure. 20% of our calories go to our brain just to function in a normal day. A chess tournament can burn as many calories as a marathon. And so we do what we can, evolutionarily speaking, to conserve energy. Energy in the evolved environment was the principal commodity. It's not so much anymore. We can eat all we want. But we evolved in a system where the more energy we conserve would be evolutionarily advantageous. The problem is, as our energy depletes, our decisions get worse. And in recognition that our decisions get worse as the energy depletes, we have developed this thing whereby our decisions in the course of a busy day become more conservative as the day wears on. Small c conservative. That is to say, I'm just going to leave this alone. I'm going to put it off till tomorrow. I'm not really going to take any risks. And the later in the day, and the more decisions you make, the more that effect will be known. So the Israeli parole study was a study of 8 judges of the Israeli parole court system, and they looked at over 1,000 decisions over 10 months. And these judges were making 14 to 35 decisions each day, one every 6 minutes or so. right? And so it's a great data set because it's a yes or no. Do you get parole or do you not? Do you sit in jail? Get parole, sit in jail. Get parole, sit in jail. Get parole, sit in jail. And so they studied this and they looked for factors influencing whether you got parole or not. And what they found was that your chances of parole went from about 70% first thing in the morning to almost zero at the end of the day, with a bump after snack break and lunch. I'm not making this up. This is the actual chart from the article. And the dotted line is lunch, and the second dotted line is the snack break. But you can see how the judge's decisions are becoming more and more conservative as the day goes on. And the really interesting thing about it, not that that isn't interesting in itself, but the really interesting thing is they did a concurrent poll of the system participants and asked them what they thought was influencing judges' decisions about whether you got parole. Not one of them, no judge, no lawyer, nobody, recognized that time of day was any effect whatsoever. Okay? That's the first important point. The second important point is whether you get parole is a highly discretionary decision of the trial judge, of the hearing judge. And so every one of these decisions could be supported in law. You could never appeal any one of these decisions on the basis that the judge only made that decision because they hadn't eaten in a while. And yet we know that many of the decisions were made precisely for that reason. And that's how, in rare instances, you can sort of tease one of these heuristics from an actual database. Okay, so no one was aware of the time of day effect, and none of that influence could never be seen in any individual decision. And if you'd asked the judge in any individual case to provide us reasons, they would have provided all kinds of reasons related to the legal test and the characteristics of the offender and all that sort of stuff. Okay, mortality salience. This one's a little bit spooky. Psychologists have found that decisions can be made more socially conservative if a subject has recently contemplated his or her own death. Okay, so what they did was a study in 1989 in Tucson, and they took judges and they broke them into two groups. And these were judges that were setting bail amounts as part of their regular routine. And they gave them the file of a fictitious prostitute. They chose a crime that had some sort of moral overtones to it. And they said, tell us what the... This is the great thing about psychology experiments. You get to lie to the people that you're experimenting on about the purpose of the experiment. So they told these judges, we're going to give you a personality questionnaire because we want to correlate the bail amount that you set with your personality and see if your personality questionnaire results correlate, affected your decision. That wasn't what they were interested in at all. Because on half of the judges, they introduced two other questions along with the standard personality questionnaire. These are the two questions. Please briefly describe the emotions that the thought of your own death arouses in you, and jot down as specifically as you can what you think will happen as you physically die and once you are physically dead. All right? Doesn't have an awful lot to do with prostitution or sentencing or anything like that. But here's what they found. The judges in the unprimed control group set an average bail amount of $50. The primed group set an average bail amount of $455. 9 times higher, simply because they were asked those two additional questions. Scary stuff, right? Okay, what does it prove? It proves that judges, not necessarily as much as lay people, but certainly in many of the same ways as lay people, their decisions can be skewed by these subconscious processes, and that they're very, very difficult to detect these errors, these systematic errors, in the course of reviewing the work product of courts. So if we find this irrationality, then it affects our work as lawyers in a couple of ways. We can learn less than we think from an analysis of reasons in similar cases, and we risk focusing our persuasive energies in possibly unproductive areas. And the important part about the patterns of irrationality is that they are patterns. What I'm trying to persuade you isn't just that we randomly fire out these cognitive errors, because if that were the case, then, well, it would be a wash sort of overall, right? I'm saying that it happens in very predictable ways, at least in many cases. And if we're really interested in what courts are doing in fact, if we really want to understand why decisions are made so that we can better predict what a decision will be, and also so that we can influence it to the extent that's ethically permissible, and that's a big question as you're probably starting to gather, right? Then that's our business. Anchoring and adjustment. This was one of the first heuristics that was discovered by Kahneman and Tversky back in the early 1970s. The term heuristic came from computer science, where it was used as a sort of mathematical shortcut that would work well enough, often enough, to substitute for the much more complicated and costly in terms of RAM algorithms that they would otherwise use. So they had these shortcuts and they called them heuristics. If anybody remembers HAL 9000 from 2001 Space Odyssey, right? That was 1969, I guess. HAL stood for heuristic algorithmic, the two thought processes that computer employed. And of course, when the heuristic stuff went astray for HAL, he turned into a psychopathic murderer. So maybe a little more ahead of his time, but that's HAL. Anchoring and adjustment was the first one that Kahneman and Tversky worked on. And what they would do was they would get their students to write down their social security number. They said, take out your card, just write down the last two digits. And so they'd have a room full of 100, 200, 300 people. And they'd all have then a randomly generated number between 00 and 99. And then they'd say, okay, put that aside. Now we're going to ask you to what you would pay for a computer keyboard, a bottle of wine, and they'd say the same thing to everybody. They'd say, it's wine, it's red, it's wet, it's from France, it's been rated at 31 stars, whatever the heck they rate wines at, and what would you pay for it? And they found that those who had written social security numbers in the top quintile would pay 3 times more than those who had written social security numbers in the bottom quintile, 00 to 99. We are pulled in the direction of numbers in particular, but other things as well, that we hear first. We become anchored to them. And it can be devilishly difficult to remove that anchor from our brain, even when we're told, hey, by the way, that number you just wrote down, that's going to be an anchor. Don't let that influence what you're going to do next. Well, we do. And that was really eloquently interested in exemplified in the legal setting when, I'll skip through Worcester for the moment. Bertie English at the University of Cologne in Germany, they used real judges in these sort of super realistic courtroom scenarios. And what they would do is they would ask the judges to sentence a fictitious shoplifter. And what they gave then was a prosecutor's demand that would be between 3 months probation and 18 months probation. They'd say, what would you pick, judge? And depending on what the prosecutor's demand was, the number that they heard first, the judge's decisions would be systematically skewed towards it. And so they said, oh, well, that's interesting. But what if the judges knew that that was just a randomly generated number? And it got to the point where they would actually have the judges throw dice to determine what the fictitious prosecutor's demand was, and they still could not defeat the anchoring heuristic. The judges would still be pulled towards it. And then they did all kinds of stuff, like they would have members of the audience shout out, set him free, or give him 10 years. And those, whether or not those things were shouted out, influenced the judges. They would have reporters come to the judges and say, is this going to be a sentence of more than a year or less than a year? And then they'd ask, is it going to be more than 5 years or less than 5 years? And depending on what they said, the judges' decisions would be pulled in that direction. The only way, then people said, well, no, but this is an adversarial system. You have to introduce the other side. So they had a defense lawyer giving the low ball, right? So the prosecutor would give the prosecutor's demand, the defense would come along and say, no, that's ridiculous, it should be Y. And what they found was, not only did the prosecutor's demand pull the judge toward the prosecutor's high number, but it actually pulled the defendant's counter demand towards it. So the higher the prosecutor's initial demand, the more influenced the defendant would be in saying what would be the sort of reasonable counter-demand. So it was extremely robust effect in these very realistic studies. There's a fellow in the United States named Andrew Wistrich, and I love Andrew Wistrich because he's been able to do what I've been unable to do. He is a federal court magistrate judge, and he's a keen interest in psychology of decision making. And he and colleagues from, I think it's Stanford, have managed to, at the annual or semi-annual, whatever it is, conferences of the magistrate judges of the U.S. federal court, 700 or 800 of them get into a convention center. And one of the things that they do is they submit themselves to experiments by Wistrich and his colleagues. And what they do is, in a very realistic setting, they explore anchoring. So in this case, they had a fact pattern in a personal injury case. The judges were all told that they presided over an unsuccessful settlement conference, but only one group was told at that unsuccessful settlement conference the plaintiffs had demanded $10 million. Everyone knew that this was not a $10 million case, but that's what they were told. And when they were finally asked at the end of the process to assess the amount of damages, the judges who knew of the $10 million demand assessed a mean amount of $1.2 million, and the judges who weren't aware of the amount, just that there had been an unsuccessful conference, would have awarded only $800,000. Now, if you're a litigator, that's pretty huge, right? That's 50% difference. That's a nice bonus on the contingency fee. And then Wistrich repeated the experiment using a low anchor. Essentially, they introduced a motion saying that this case didn't even meet the $75,000 federal court threshold. You shouldn't even be hearing this. Every judge rejected that because they clearly recognized it was more than $75,000. But those, again, who had been exposed to the low ball awarded almost the mirror image of the first experiment. They awarded 882, whereas it was 1.2 million for those who hadn't been exposed to the low ball. Okay, so those are anchoring effects. The only thing in the German experiment, the only thing they could do to change that outcome of being pulled toward the prosecutor's demand was to reverse the order of presentation. If the defendant went first with the low ball, the judge was predictably pulled towards the low ball. And we're often taught, it's very important to have the last word. Oh, no, it's very important to have the first word. It really is. And they measured this in all kinds of settings. They've done experiments in boardroom settings trying to figure out why in committees, the initial reason for studying it was that women were not persuasive in those environments. And so they said, why? Is it a height thing? Is it a tone of voice thing? Are they being shouted over? Is it that kind of thing? And they found that when they controlled for who spoke first, the women were just as influential as the men were. They just weren't speaking first often enough. And so you can manipulate the sequence in which people speak, as courts do. For instance, many appellate courts will have the most junior, when they go back to conference about what the outcome of the case should be, they'll have the most junior person speak first, and then go around the table that way to avoid inordinate influence by the senior judges. Okay. Availability and credibility. Okay, so this is another heuristic that's been measured more in the non-legal setting. And this is one of my challenges, is to sort of argue by analogy that so much of this non-legal research should be applied in the legal setting. So what's credibility? How do we determine credibility? This is obviously very important to lawyers. It's very important to judges. We know that information enters our brains through different routes and is received differently depending on how it's presented. And they find that information that's more what they call available is found to be more credible and more truthful. So how do you enhance availability? It's through a lot of weird things, some of which you wouldn't expect. This is the truthiness experiment. This is with a nod to Stephen Colbert. The researchers called it truthiness. These were a New Zealand experiment. And what they would do, they wanted to find out the influence of photographs on our assessment of credibility of statements. So they'd have a statement, turtles are deaf, right? You believe turtles are deaf? Well, a certain amount of credibility is attached to that. A certain number of people in any group are going to believe that turtles are deaf when they're presented with that. Then they did this, turtles are deaf, right? A completely non-probative photograph, but a related photograph. It does show a turtle. It doesn't show whether it's deaf or not, and yet it increased the credibility of that statement between 1.5 and 2 times. Simply showing a non-probative photograph. And they tested it very quickly. They said, oh, that can't be right. So then they said, turtles are not deaf. And you know what? Twice as many people believe that turtles are not deaf when they were showed the same stupid non-probative photograph of the turtle. Evolution has some fascinating explanations for this, and my personal favorite is that simply we didn't evolve for photographs. We didn't evolve for movies. Our lizard brains cannot distinguish the difference, right? There's a $10 trillion pornography industry premised on exactly that thing, that we can't distinguish the difference between two-dimensional pixels and the real thing. We cry at movies, right? We know at every level of our rational brain that the stuff isn't really happening, but our lizard brains can't distinguish, and so we have emotional responses. So I think that this is part of a sort of verifiability thing. We don't know the difference between that and a real turtle. And if someone comes up to you and says turtles are deaf, you might believe it, you might not believe it. If someone comes up to you with a turtle under their arm and says turtles are deaf, you're going to go, I can test that. You know, I can find out if that turtle is deaf. And so that statement may have more credibility just on that basis alone, because we simply can't distinguish it. And we've done some experiments around truthiness at the university. If I have time, I'll mention them. But let me just rattle off a few more heuristic effects that are at play in the courtroom. And many of them have to do with the characteristics of the lawyer, of the advocate themselves. And the Greeks called this ethos. And they recognized it as fully 1/3 of the sort of area of persuasion. That simply the gravitas of the advocate, him or herself, in those days it was always him, influenced as much as the logos, the logic, or the pathos, which is the emotional appeal, and we can talk about that a bit too. But why is one person able to persuade and another person isn't? Well, we're getting a lot of clues. We can even imagine that lawyering itself is premised on a heuristic, at least to an extent. We know that when they've done experiments in hiring situations, for instance, that people come in and they speak about their resume, that's given a certain amount of believability and persuasive force. If they come in with an agent, and the agent says exactly the same things about that person's resume, it's about twice as persuasive as when the person says it themselves. And in fact, it's the same even if the decision maker is told that this is simply a paid agent and they're just parroting what the person would say on their own behalf. There is an innate deference that we give to people who are advocating on others' behalf. And if you think of yourself in that Paleolithic society of 50 to 150 people, it makes sense, right? Someone that has someone to vouch for them is a person that you're more likely to want to be allied with, that you're more likely to want to defer to, particularly if the person making the statements is a sort of respected higher status member of the community. So we have a deference to advocates. Sean Rehag, I just mentioned this study. He studied at Osgood the chances of success in refugee applications. And he had a magnificent database, like tens of thousands of decisions. And he wanted to show that you're much better off with a lawyer than you were when you were self-represented. Sure enough, that's exactly what his data showed. And he sort of ran off and made the political point about that we shouldn't cut back on legal aid for lawyers. But when I looked at his data, I saw that he had 3 categories. He had self-represented, he had lawyer represented, and he had other. And the lawyers were about 70% successful, and the self-reps were about 12% successful, if I recall right. And so I'm saying, well, who is this other? Well, the other was members of the family, representatives of non-governmental organizations, anyone that would show up and speak on behalf of a refugee applicant, apart from the refugee applicant themselves. And what did they find? those people were almost as successful as the lawyers were in those situations. And that has huge implications for when we're talking about access to justice and system design, right? Because, you know, there's sort of two schools of thought. One is we should help self-reps represent themselves through better internet and all the rest of it. And the other is simply that we should provide maybe cheaper non-legal advocates. And I'm certainly of the latter school, especially after reading this. That there is no amount of training that you can give to someone that is going to level the playing field when they have an advocate on the other side rather than the person. Okay. What is beautiful is good. This one is controversial because I confess, it's going to shock you, I'm not a beautiful person. But what they find is that people who are attractive, as they've been able to measure it, and it's usually done through symmetry, left to right symmetry of their face and bodies, people who are more attractive are perceived not only to be more attractive, but actually to be more honest and more credible. People who are taller are perceived to be more honest and more credible. The things they're saying are said to be more truthful. Those are bizarre when you think of them. I mean, those are counterproductive if those are influencing you in pretty much any environment, except an environment where you would want to ally yourself with people who are taller, healthier, stronger, and all that sort of stuff, right? So that has a sort of lingering influence. And there's, you know, interesting research done in politics showing that very young children can choose the results of previous elections much more accurately than pollsters can, simply by measuring whose face the child fixates on for a longer period of time. Deference to status and wealth. We comply with people who are perceived as wealthier with higher status. It's called costly signaling theory. They do experiments. They have university students standing in a mall with clipboards, and they say, do you mind if I ask you a few questions as people walk by? They have no interest in the questions on the clipboard. What they want to know is whether you stop to answer them. Simple compliance with a request. And what they find is, on one day they dress the students up in a nice white sweatshirt with nothing on it, and on the next day they dress them up with the same sweatshirt, but with an expensive fashion logo on it. And what they find is when you're wearing an expensive fashion logo, you get about twice the rate of compliance than you do when it's a plain sweatshirt. And so you will see lawyers trying to costly signal their wealth and status in a bunch of different ways. And you could think of, for instance, our habit of gowning lawyers in Canada and England and some other Commonwealth countries as a sort of tacit recognition by the system that that's a heuristic that should be thwarted, that it should be countered. And a lot of the aspects of our system design are to either exploit or counteract heuristics, I would argue. The fact that we elevate judges, people who are in an elevated position, our subconscious brain thinks are taller, more powerful, and we are more deferential towards them. I think of all those propaganda posters from World War II, doesn't matter, Russia, Germany, America, you know, they're all showing brave soldiers, they're all shot from underneath, right? They're all painted from underneath for a reason, because we defer to people that we literally look up to. Okay, affinity biases. This one probably won't surprise you, but we find people to be more credible and truthful if we consider them to be parts of our groups, in-group and out-group effects. I won't take you through my gun nuts experiment. It's kind of a fun thing I do with my students. Social proof, which is a related concept, is the idea that we are herd animals to a large extent, and we want to follow the crowd. There's a great experiment they did in the Arizona petrified forest. They found that tourists were always going there and picking up souvenirs and taking them away, and that if it kept it up, soon there wouldn't be anything left of the petrified forest. And so they hired Giordano and his Giordini and his allies to develop signs that would discourage people. This was before the days of video cameras and automatic machine guns, I guess. So they decided to do it through a sign, and so they developed this sign. Many past visitors have removed the petrified wood from the park, destroying the natural state of the petrified forest. And what they found was, that it tripled the rate of theft from the petrified forest. Why? Because they're saying, everybody's doing it. Don't do that. Everybody's doing that. And we're hearing, everybody's doing that. Everybody's doing that. Everybody's doing it. And that's a very powerful persuasive technique. When one of my first cases was working with Tom Berger in the tobacco litigation, and we were defending the constitutionality of the government's lawsuit against the tobacco companies. And his mantra was normalize, normalize, normalize. You know, we had a very unusual statute. It was very susceptible to constitutional attack. We had to present it as normal. And that's what you try to do with your clients. You try to present what they're doing as normal and what the other person's doing as abnormal. And it makes a big difference. They've done experiments where they have a car accident and they say, we want you to assess the liability of Joe Bloggins, who was racing through this intersection and had a collision. And they say, with one group, yeah, Joe Bloggins was racing to get home because he realized that he'd left his parents' anniversary gift out on the dining room table, and he had to get it home and hide it away before they got home, right? And then with the second group, they'd say, oh, Joe Bloggins was racing home because he'd left his drug paraphernalia on the table, and that he had to hide it away before his parents got home. Completely legally irrelevant to whether he was liable in the accident, and yet you can guess overwhelming liability when he was racing home for the drug paraphernalia, and very little liability when it was all about mom and dad. Okay, our conformity with stereotype. We're very influenced by stereotype. Obviously, this is not an endorsement of that phenomenon, but a phenomenon it is certainly seen to be. And that's exemplified by that very first experiment I told you about with the male and female job applications. Representativeness, heuristic. We have a strong tendency to form a view based on anecdote and stereotype compared to a true probabilistic assessment. Tell you a quick story. In the polygamy case, we had developed all of this very high-level expert evidence from people top of the field. Joe Henrik here from UBC, he's now at Harvard. He was our main expert witness. We had a woman from Brown's University. We had the chair of the classics department from Stanford. I mean, serious high-level stuff, and I just loved that. I mean, I was just all over that. And then the lawyers in my team convinced me that we weren't going to win this case if we didn't have actual on-the-ground evidence from the survivors of polygamous communities. And so they went off into the hinterland down to Utah. They did video affidavits at truck stops or whatever they could. Found all this evidence. We put it before the court. And at the end of the day, it was incredibly persuasive. And we won a case that people said, you have no business winning this. For 30 years, they said that the law was unconstitutional, and yet it was upheld. And, I think it was upheld for that reason. Did you find that story persuasive? You see what I just did there? I told you a story to convince you that telling a story is more persuasive than just presenting sort of dry anecdotes and whatnot. And that was the sort of reason I did that. And that's why every good litigator, I mean, we've always recognized this, every good litigator will say, if you don't have a story, if you don't really have some way of putting the white hat on your client, a narrative, even if it's not strictly legally applicable, for heaven's sake, if he was rushing home to hide his parents' gift, say that, right? Because those kind of things are very, very influential. All right. I'm going to skip through some of this stuff because I know I've got way more slides than the heat in here can bear, and I appreciate you sticking with me this long. Oh, that's a good idea. Can we open a window, Mark? Is there yeah, let's do that. Okay, yeah, if we can get a bit of a crossbreeze going through here, that would be terrific. So tell a story is the advice that's often given by counsel who know what they're doing. And that's very well backed up by the science. Normality bias, I've talked about that. Omission bias, believe it or not, we find that we associate more wrongdoing with deliberate acts than with inaction, let's put it that way. And so skillful lawyers will characterize the defendant's inaction, for instance, as somehow active. And one way of saying that is you might say, yeah, he elected to do nothing. He made the decision to be negligent. Whereas in fact, what the person did was nothing. But the more active you can present that, the more likely that fault will be attached to it. There's some sort of odd ones that I'm still trying to figure out how it sort of works in here. But we can make decisions we can make people more conservative or liberal with cues that have nothing to do with the arguments that we're making. And fear, if you guys have been paying attention to what's going on in the States, is a huge motivator for conservative, I'm talking sort of capital C conservative here, thinking. And when they measure people who self-identify as conservatives versus self-identify as liberals, what they find is that the amygdala area of the brain is far more active in conservatives, and that's the center that, among other things, controls fear and some of the more primal responses. But what they've actually also found, so they find that people who self-identify as conservatives, when they're presented with a series of photographs, fixate on danger, photographs depicting some danger, a snake as opposed to a flower. They fixate on it sooner and they fixate on it longer. And so there's a notion that conservatism and fear are linked, and that you can actually manipulate this to an extent by making people more fearful. And I speculate that one of the reasons liberals are having so much trouble fighting in elections is that they tend to do it by invoking fear of conservatives without realizing that fear just generally, the state of fear, the sense of fear, skews people more conservative. And that can be triggered by bizarre things. When they ask people, about sexual activity or immigration, if they ask them those things when they're standing beside a hand sanitizer dispenser, people's responses are predictably more conservative. Or if they just put a sign up on the wall saying use hand wipes, people are more conservative in answering those questions. So I don't know how that plays out in the courtroom, but holy cow, you got to be careful at election time nowadays. Now, of particular interest to lawyers is how our arguments can be arranged to make them more persuasive. And there are some kind of bizarre effects there too. So sequence of presentation I've discussed. She who speaks first generally prevails. Having the last word isn't the most important thing. Word and phrase manipulation, and this is getting back to the availability heuristic, how easily information enters our brain. If we use words that are familiar to the decision maker, we're far more likely to succeed. And it won't be long, if it isn't happening already, I think, if you know who your judge is in a particular case, you're going to run, if you're smart, all of those judges' previous written decisions through an algorithm that turns it into one of those little pop chart things, you see, with the most often used words, the biggest, and all that kind of stuff. I mean, that technology exists on everybody's laptop right now. And if you could find which words the judges prefer, and if you can find words that are perhaps a little more unusual, that aren't everyday words, you salt your argument with those things, and it makes it more available to the person reading it. Sequences of three, the Greeks again recognize this, the power of things that are put in threes, and you'll see politicians do this all the time, but we also do it in our legal arguments, and they've done all kinds of experiments where we hate having to choose from 9 different things, and we hate having only one choice or 2 choices. Once we get to 3, more satisfying, right? They sell jam, in these experiments in the supermarket with the little sample jars and all that kind of stuff. And at one table they have 3 types of jam, including strawberry, and the other table they have 20 types of jam, including strawberry. And guess what? People buy twice as much strawberry jam when it's at the table of 3 compared to when it's at the table of 20. And more than that, when they recontact those people a week later, they report the jam as being sweeter, better tasting, more satisfying when it's from the table of 3 than when it's from the table of 20. 3 is a magic number. Use of rhyming or structure. Oh my God, this shocked me. If the gloves don't fit, you all remember that, right? How many, this has been about 25 years? Right? We all remember that. Why? Because we evolved before writing. We evolved when we were transmitting messages to each other in ways that could be memorized and repeated. And the important messages in a community, the truthful messages, the great truths of the community, would be communicated through song or through rhyme as a mnemonic effect, as a memory aid. And so we have evolved this thing, and it's been quite quite persuasively measured that if you can make a sentence rhyme, it's considered to be more truthful than the same sentence structured so as not to rhyme. Evocative word choice, smashed versus collided. When they ask people how fast a car was entering an intersection in a video, when it smashed into the other car, they say predictably faster than if they say when the cars collided. And then people will remember things. You ask them 3 months later, oh, remember that video you watched? How much glass was there on the ground? And people who would then, the word smashed was used, would report all kinds of glass everywhere. And the people, when you say collided, oh, no, there was no glass. And you know what? There was no glass. These people's vivid memories of the glass on the ground were entirely created by the use of the word smashed. Okay, so my sort of shtick is that the decision based on extra legal factors is not truly judicial. And I have this case from Patrick Devlin's beautiful book called The Judge, where they basically said that if a court isn't, the court in this case was given the power by the legislature to depart from the ordinary rules of law or equity in making its decisions. And when it got to the Privy Council, they said, that's not law at all. That's not law at all. And the risk that we have, I think, with our increasing understanding of these heuristics is not that the rule of law really is in peril. Because even if every one of these decisions was purely fictitious, even if it was just a Hansel and Gretel story, provided it's providing some instruction to the rest of us for how to behave, then the rule of law is kind of preserved, even if each decision is in itself a fiction. What is, I think, threatening is, first of all, that adjudication to the individual litigants is less fair, and second, that the potential for manipulation is just out of this world. And we've always known, I mean, what is advocacy except the use of techniques that go beyond a simple recitation of the facts and the explanation of the law? If there's anything to advocacy, it's always been on that semi-subconscious level. Every lawyer knows you don't put a witness on the stand in a sweatshirt. You put the witness on the stand in a suit and tie, and he's more credible, more believable. Well, that's nothing but manipulation of bias. It has nothing to do with the truth of what the witness is saying, but we've all done it, and we've done it forever. There was a, I don't have the quote here. There's a great quote. My favorite book on appellate advocacy is by Scalia and Garner, the now late U.S. Supreme Court judge, and Garner was the author of Black's Law Dictionary, so they got together and wrote this book on advocacy, and it's just fabulous. It's a little tiny book. For the law students out there, it's way too expensive, but you can sit it in your bathroom, and every time I do an appeal, I pull the book out again and read it through. It's really good. But they said in one little section, you know, when parties appear before us representing American Airlines, they usually call their client AA, maybe as a space-saving technique. And he said, that misses a real opportunity, because you can shorten that client's name to American. And you're going to be up against, in every case, an American judge, right? And not before, an American judge. And that will subconsciously influence that judge to be more sympathetic to your client. Now think about that. They're saying subconsciously influence. They're not only recognizing this, they're endorsing it as an advocacy technique. A justice of the United States Supreme Court is saying you should use subconscious techniques of manipulation to the advantage of your client. And we always have. But the question now, as we're getting to these understandings, and some of these things are so spooky, it's like, you know, reaching out with a death ray and zapping someone with mortality salience, and suddenly, you know? So as we get more sophisticated with this, as you will see if you haven't already, in large trials with large dollar amounts at stake, a consulting psychologist studying the judge, right? as we see those sorts of things, I think the ethical boundaries are going to become more and more and more important, and may be one more factor in favor of tipping adjudication towards artificial intelligence. Although I think that will be resisted because of our innate heuristic bias in favor of deferring to a high-status member of the community, and that we will not defer in the same way to a high-status, very well-educated, more accurate computer, because something in our lizard brain says, powerful person, I agree with you, right? And I think we are going to be too attached to that, at least in the next decade or two, to turn things over entirely to computers, even though they are right now on the verge of being able to make better, more accurate judicial decisions than judges. Okay. So we've got a lot of challenges about research in the legal setting, obviously. It's very hard to perform experiments on judges, and it's a very rare database that you can get to experiment with. Let me just say one piece of research that we did at TRU soon after I got there. Michael Rankin, a colleague of mine, a terrific lawyer, appellate lawyer. We looked at parole ineligibility decisions in Canada, right? Everyone who gets convicted of murder in Canada, second-degree murder, gets a life sentence. But the judge has a discretion to impose 10 years to 25 years of parole ineligibility. That is how long you actually sit in jail. So it's effectively the sentence, and it's between 10 and 25 years. And so he said, well, can we look at these numbers and see if there's any anchoring effects or anything that's going on? So I said, sure, let's map them out. Let's see what we find. This is what the court's supposed to take into account when sentencing offenders. The character of the offender, the nature of the offense, and the circumstances surrounding its commission, and the recommendation, if any, by the jury. That sounds like an awful lot of discretion, doesn't it? And it is. I mean, it's an almost entirely discretionary decision, very unlikely to be challenged or overturned on appeal. But these were the results that we found. And what you would expect if all that was being considered were those criminal code factors would be perhaps a gentle slope from 10 years to 25. And maybe a little shoulder at 10, because everything less than 10 would be pushed up to 10, and maybe a little shoulder at 25, because everything over 25 would be pushed down that way. But this is what we found. It's all over the place. Look at 20. 20 should be about the same on a random distribution as 19 and 21. Oh, thank you. Not just a round number here, but multiples of, which has nothing to do with the criminal code criteria, but an awful lot to do with the fact that we evolved with 5 of these on our hands, right? And those are what our counting systems are based on, and we have a subconscious bias towards them. 10, 15, 20, 25. It's like clockwork. And then when we looked at the rest of the numbers, it didn't get much more reassuring. It turned out that if you looked at evens versus odds, in Canada you're about twice as likely to get an even number sentence as an odd number sentence. No reason behind it, no legal justification for it, just our lizard brain ticking over. And it's not just the judge's lizard brain, right? Because all of the system participants are pitching these numbers around. So prosecutors, defendants, defense counsel, they're all going to be preferring these same kind of numbers, and so this is the kind of distribution pattern that you would expect. But unnerving, right? And look, no one really cares that a murderer is sitting in jail for 1 extra year, pshaw, right? Who cares? You might care if you think that, well, actually maybe they're getting out a year early, before it would be safe to release them. But whatever you think about whether this has any significance at all, and this is really kind of a parlor trick sort of experiment, what it really does show is the profound influence of these things on judicial decisions. And it behooves us to say, if this little simple thing can't be overcome, if it can be viewed so clearly from the decisions that we're able to examine, then what else is at work here? What else is going on? So I say we're sort of all legal realists now, that no one really accepts anymore the sort of formalistic idea that they still kind of teach in law school. I think now of legal education as kind of like education in physics. You know, we're taught in grade 11 or 12 or whatever it is, oh, this is what the, this is what the atom looks like. You've got a little center with whatever you got in the center, and then you've got these electrons whizzing around it like little planets. And that's a useful fiction, right? It helps us conceptualize things in the early days. But boy, if you're still thinking that way by the time you're doing graduate work and leaving Green College, doing graduate work in physics, then your career is going to be short. I think it's the same for lawyers. We have to go through that phase of logos, of learning that application. But if that's where we stop, then I think as advocates, it's going to be a short career. Jerome Frank, I love this, was notoriously thought to have said that legal decisions could turn on what the judge had for breakfast. And, juxtapose that with the Israeli parole experiment, right? You think, ooh, geez, not far off 100 years later. And Holmes used to talk about inarticulate and unconscious judgment. And many judges, and I read every judicial biography I can, many judges will quite openly admit that their process of decision-making follows what Wistrich calls intuition override. That they come to an intuition about a case or about an aspect of a case, and they can override it with their consciousness if they, focus enough on it. And we try to encourage judges to have manageable workloads and shorter work days and whatnot so that they can exercise that. But they nevertheless say, that's really where the decision comes from, something in my gut that gives me that intuition about the way it come out. And that seems to be sort of a recurring theme with at least many of the most reflective judges. Albie Sachs, the great South African constitutional judge, very famously said that he comes to most of his most difficult decisions in the bathtub. That he'll work, on a case for weeks or months, and then relax. His mind kind of goes clear, and he just comes up with the hunch. And then he tests it. He goes back and tests it. Sometimes the judges say the decision writes, and sometimes it just doesn't write. And that's usually because there's something jarring between those two systems. Yeah, sorry. I think I can probably safely leave it at that. So let me just leave you with Mark Kelman's words from the Heuristics debate, which is a nice sort of collection of essays. Everyone who writes about heuristics worries, at least to some extent, about both advertisers and sneaky lawyers. I think we're also being increasingly concerned about sneaky Russian trolls and sneaky politicians as well. But so let me leave it at that, and we'll throw it open for some questions, and I'll be around for the reception and for dinner after if anyone wants to buttonhole me, please.